Welcome to your weekend. I'm Mike Krause from the Independence Institute, filling in for your usual host, John Caldera, who should be back here next week, we hope. Stick around just a little bit because we're going to talk about a significant ballot measure, Amendment 73, a little later in the show. But first, the Republican candidate for Attorney General, George Brauchler. How are you, sir?
It's great to be here. Thanks for having me.
No, thanks for coming by. I really appreciate it. Awesome. All right, so first, we want to talk about some of the philosophical underpinnings, what the AG is, and how you see the office, because I think there's a pretty significant divide between you and your opponent in view of the office. First, I wanted to talk about a Washington Times column you wrote. And criminal justice is part and parcel of the AG's office, but it's certainly not everything the office does.
Right.
But you said some pretty interesting things about criminal justice reform. And as AG, you would have a pretty loud voice with regard to policy change when it comes to criminal justice matters. And you bring up this interesting idea of sunsetting criminal law. We already do this for regulatory stuff all the time. In fact, it's a fantastic idea because if something's not working, or if there's overreach going on, or if things change to where, frankly, we don't even need that rule anymore, we can allow it to sunset or the legislature can renew it. Explain what you mean by sunsetting criminal statute.
Well, it's the same idea, and frankly, I can't take credit for it, although I will on your show.
Yeah, go ahead.
It was actually a guy named Thomas Jefferson.
We're big advocates of taking credit for other people's work.
Yeah, well, I gave Thomas Jefferson the idea when he wrote the letter back in the late 1700s to John Adams, but the idea is the same, and that is that, look, if you allow laws to just live in perpetuity until we sort of use this fake power of repeal, and that's almost impossible to accomplish, you've really allowed the last generation, the past generation, the dead generation, to exert way too much influence over us. I think that what we should do is sunset every criminal law to force us all back in under the gold dome on a periodic basis to reassess, does this law work? Did it accomplish what we want? Does it suck? Is it no longer applicable? Is there something else we should look at? And I think if we build that into our culture, then we will not only have better control over the laws that govern us, but we will expect to have that kind of change and malleability in law. I think it would be a fantastic thing for Colorado to take the lead on. I
think of an excellent example that back in the 80s, the legislature passed this broad sweeping criminal sentencing statute. Big piece of legislation. And we didn't even stop to look at it again for 25 years when we didn't have any more money to build prisons in this state. Right. And we were starting to bond them and use certificates of participation. And then all of a sudden, over like the last 10 years, we started doing little pieces of reform towards some of those things that simply weren't working or that were simply too broad. But under your idea, if they wanted to, if the legislature, man, they like creating new crimes down there. It's interesting sometimes. That if they wanted to create a new criminal sentencing statute or a new crime, basically they have to go back, be forced to go back and look at it pretty quickly rather than a quarter century later.
Right, so my thought would be, and we can make up any numbers we want, but on a brand new law, brand new sentencing scheme, we say, hey, we're all going to get back together in 2 years or 3 years. That initial sort of look back and say, okay, is there anything glaring, sweeping we need to look at? And then maybe every 7 years after that to say, is this still applicable to our society? And you talk about laws that we have in place that we try to figure out a way to beat other new crimes into, like no one could have imagined revenge porn back when I was in high school. Sure. I mean, there wasn't anything like that. It was all just Polaroid pictures, and nobody did that, I mean, that I know of. You talk about social media harassment, threats that are made. These are things we couldn't have envisioned back in the 80s or the 90s and maybe even the early 2000s. And so we end up trying to create new laws to cover it all. I think we ought to take a very judicious, conservative, and appropriate approach and say, let's come back and pronounce those things dead. And if we like them again, we'll breathe life back into them. And that would work great for sentencing as well.
You also brought up the idea of pardons, that you know, the governor can make pardons, and usually you see pardons in the last couple of years of their term when they're comfortable with, you know, they may pardon someone that angers somebody. We don't know what might happen. But you say that the pardon should be, we should probably be doing this more often, that it should be something we look at carefully, but that it should be a little bit more common. Do I have that right?
100%. Yeah. Pardons are earned. I don't think they're just bestowed at the end of a political career when someone feels like they're safe. And if someone that they pardon ends up going out and going all Willie Horton, that it won't affect them in the future. I think that that is political gutlessness. This pardon power is pretty broad. If you look at our state constitution, there aren't a lot of requirements that the governor has to abide by. And so what we ought to be doing is finding those exceptions to the rule, those people that should get the functional equivalent of governmental forgiveness, and not just roll them out with a paper press release. We ought to celebrate this thing, right? Like, this is the best possible outcome for the criminal justice system. Here's someone that has come out and not just not committed a new crime, but they've achieved some milestones that put them so far and above their peers that have been prosecuted that we come out and say to people that have felony convictions, you make a mistake at an earlier part in your life, that does not have to define you for the rest of your life.
There is this kind of this debate that goes on about when have you actually finished serving your sentence, right? Even though after you're released, you still have that felony hanging around your neck. Man, that thing can really screw up the rest of your life.
100% it can. I mean, I'll give you an example. Low level, and what the term that people use a lot now are nonviolent felonies. But you get a felony conviction at any point in your adulthood, that thing stays with you 99.9% of the times for the rest of your life. That affects things like your ability to exercise your Second Amendment rights. Yep. It affects your employability. Sometimes it affects whether or not banks want to trust you with money. What we ought to be doing is taking a look at a certain level of crimes committed at a certain age and saying, are these the things that should define a person moving forward? So, 24-year-old guy, certainly an adult, steals a car. Probably going to get you a felony conviction. If that guy lives 5, 10, 15 years of crime-free life, achieves certain milestones in terms of education and employment, should we still call that person a convicted felon? Do they go into the ground with that title earned from that horrible thing they did when they were 24? I think we got a better system that we can put in place.
All right, sounds really interesting. In fact, it's a great topic. It's just ongoing. Let's talk a little bit about the office itself, the AG, the kind of the ideology behind being Attorney General. And I might get this a little bit wrong because I'm not a lawyer. I played one at home for years, and then ended up divorced.
That's right.
So it didn't go particularly well.
There are also jailhouse lawyers. Ever been one? No, don't answer that.
I've never been a jailhouse lawyer. All right. So there's a lot of people who say, that the AG is essentially the lawyer for the state government or state agencies, and that is actually written in the description of the Attorney General.
True.
But the AG is not also the lawyer for the people, and so at sometimes those two things are going to come into conflict, right? And I think about this, and this was so amusing, but the current Attorney General, Cynthia Kaufman, signed on to a lawsuit against the Obama administration over the Clean Power Plan, and thankfully they were successful.
Right.
Governor Hickenlooper said, no, I did not authorize you to sign on to a lawsuit against the federal government, so don't do that. And he actually went to the Supreme Court and asked the court to tell Attorney General Kaufman that she couldn't do that without his permission, to put it in layman's terms. Right. And the court said, no, absolutely not. So talk about that. When are you the government's lawyer, and when is you the people's lawyer and you might be doing something that the governor doesn't particularly care for?
Well, it's true that as the Attorney General, you represent every single aspect of state government with the exception of the legislature. So governor has issues, judiciary has issues, they get the AG. Any one of the cajillion agencies out there protecting our water, all things fall into the AG's purview. Legislature gets into trouble, they got to call Bacchus and Shanker. They don't get the Attorney General's office. But that client relationship they have with the governor and these other agencies is different than a normal attorney-client relationship. The governor doesn't hire me. The people of the state of Colorado hire me, and they hire me for a very specific purpose, and that is to exercise independent judgment in the enforcement of the laws and the protection of our Constitution. And so with any governor, and I imagine this is what General Kaufman did with Governor Hickenlooper, was to say, this is what I think I am compelled to do by my duty to the law and by my duty to the Constitution and my duty in this role. And the governor says, well, I'm your client, I tell you not to do it. The problem is she's independently elected, a constitutional officer. Governor can't fire her. Governor can't withhold funds from her. So the one provision of the law that remains is the governor can go out and seek outside counsel, at our expense, by the way, which sucks, but at our expense, and can represent his interests in that way. And I think what you see is a growing trend among governors who don't like the answers they get from their AGs to going out and trying to hire big silk-stocking law firms to carry their water for them.
You actually had that not too long ago, that the governor wanted to sue over the Trump administration blocking methane rules. Attorney General Kaufman said, you know what, I don't see it. I don't see this as a conflict.
Right.
And the governor went out and hired outside counsel.
Yep, and you know where else you saw it too was, you remember the Martinez case?
Yeah, we talked about on this TV show.
2-1 appellate decision that fundamentally changes the way administrative agencies rule make and how they engage in balancing, specifically the Colorado Oil and Gas Conservation Commission. But here's the killer. They are a client of the Attorney General's office. The Attorney General's office works for them. They took a very public vote at the request of the governor, unanimously voted to appeal it, and then when she did appeal it, the governor said, well, I order you not to appeal it. It doesn't work like that. That is not how the relationship works.
It'd be nice if it did, from the governor's point of view, I imagine.
I think it would. But then, there are states that have appointed attorneys general.
Sure.
We don't want that in Colorado.
You essentially would end up working for the person
right.
who appointed you.
That's right.
And there'd be no independent judgment. And I think this is actually a great part of our checks and balances, that this office is an independent office. In fact, all of our constitutional statewide offices are independent offices.
And if you look at how we've done it statewide, too, we're the only state in the country that has a Democrat governor and a Republican attorney general, and it's been that way most of my life. And the one time we had a Republican governor,
we had a Democratic attorney general.
So Colorado embraces the separation and the balance, I think, that it gives.
And it seems to work pretty well, actually, in the long run.
It does. I really
All right, so there's this other idea that within the AG's office, and it's kind of more like a doctrine. And if you were to think, so if the Attorney General thinks something that the legislature does is unconstitutional, and it's challenged, right? So it would be the AG's job to defend it. But if the AG thinks it's unconstitutional, but it's defensible, and that is that there's actually an argument to be made that's actually a legitimate argument, there's an obligation to go into court and go ahead and make that argument. And I think the perfect example of this was Attorney General Suthers, who said he thought the 15-round magazine ban that the legislature passed was unconstitutional. But there was precedent for 10-round magazine bans that had not been adjudicated. So there was actually a defense, and so he went ahead and defended that law. Talk about that. What happens when you think something's unconstitutional but still defensible?
Yeah, my preference would be to not be in that kind of a pickle that has and could exist again, and that is you want to cling to the idea and push to the legislature the idea that they should be passing laws that are consistent with the Constitution, but knowing all the while they don't work for you either, and you don't work for them, and they can take different legal advice and pass that 15-round magazine ban. And then you're stuck in this position where it's like, look, I am duty bound to uphold and defend the laws that we put on our books unless there is no legitimate or ethical argument that could be made to not defend that. And I suppose that could happen, and I'm trying to think of what that would be in particular. If the legislature passed a law that banned all weapons for all purposes at all times. I do not believe that the Attorney General would be duty-bound to defend that because it flies in the face of obviously, of a constitutional right in a way that I don't think ethically you could argue otherwise. But where there's an ethical and credible argument, you end up in a pickle here between these two things. The hope is you've developed enough of a credibility and a relationship with the legislature that you can get them to the place where they can accomplish their policy objectives within the law. And I will tell you, when you're talking about differences between AG candidates, that's the other thing. Our Attorney General in this state should not be a policymaker. They may have points of view that they want to advance, ideas that they have that they give to the legislature, but the Attorney General is in the business of executing the laws and defending those laws in the Constitution, not making policy.
You know, actually, as long as we were talking about guns and magazines and et cetera, let's talk about guns in the Second Amendment. That you gave back at the legislative session, there was this bill introduced, and it was introduced in the waning days. There was no possible way it was going to make it through. But you went down and testified, and you gave what I thought was like lukewarm support for the concept of a red flag for being able to come in and take guns from somebody who's mentally unfit to have them. And so that bill didn't make it through. The idea is still out there. And so, so you're okay with the idea as long as the proper checks and balances are in there and the due process. Let's talk about red flag and how we. Yeah, I'm sure you never did. Sure, nobody called you on the phone and talked to you about it.
No social media attacks, nothing like that.
No social media. This is going to come back, I'm sure. Yeah. And so what was wrong with the first one, and what would you like to see in a second attempt at this? And by the way, that doesn't mean that there's not a path towards this.
Right. And listen, even at the time that I stood up to support this idea with the sheriffs from Arapahoe and Douglas County and Representative Wist and others, I had said, look, I'm skeptical of giving the government this kind of authority. I mean, I am a skeptic about the amount of power the man gets, and I am the man in my jurisdiction, right? But I'll tell you what happened is we got to a place where it became clear that the ex parte provision is the single most dangerous and I think susceptible to abuse part of this.
You might need to, let's step back for a second. Explain that, because let me see if I can put it into non-lawyer terms. That basically, you could have a hearing about me that I didn't have to be a part of.
That you would not be a part
would
of.
not even be allowed
Yeah.
to be a part of.
Well, you could be if you knew about it, but here's what happens is law enforcement, maybe your mom, your dad, your wife, girlfriend, son, daughter, something like that, says, hey, I think he's coming off the tracks. He's becoming dangerously mentally ill. They go give a sworn statement to the court under oath. The court then can issue a temporary order permitting law enforcement to then go and temporarily seize those firearms. That ex parte provision is the part that is the most susceptible for abuse. And what the things that you hear about, not just in the hearing, but on the street are, well, look, what if it's a disgruntled ex-girlfriend who just says, look, I'm going to go burn down Mr. Smith. And so they go in and make a whole bunch of wild accusations. It is of little consolation that she could later be held accountable for perjury once someone's gone into their house to take their guns. And I believe that. But then here's what's happened. You know, the initial idea for this grew out of a bunch of different bills, one of which was out of Indiana that they'd had for 12 years and used only 47 times. Now that bill is far more liberal than this one. But here's what has really plagued me since then. You look at Broward County, Florida, and it has been used more than 34 times in less than 6 months. By some accounts, 300 separate warrants have been sought off of this.
That's a lot.
That is a ton, and that is the kind of abuse that I think that one provision makes that entire bill susceptible to. Now, I am still sold on the idea that we want to keep firearms out of the hands of the dangerously mentally ill. This approach just isn't going to be the fruitful way to tackle it. If you ask me, my druthers, we're putting resources into mental health because those tools aren't in the law enforcement officer's toolbox, and we fix this 72-hour mental health hold because right now the standard is completely untenable in the practical real world. If we tackle those things, then we've solved the problem without ever having to get into someone's home and taking their property from them.
Absolutely. But this issue is coming back, and if you're
for
the
sure.
Attorney General, you'll certainly be asked about your opinion on it, I'm sure.
I'll be at the Capitol giving it. Yeah.
All right. Appreciate you coming by today. Thanks so
Cool.
much. Stick around.
Yeah.